My biggest concern at this point is the fact that this is from November 7th and you guys don't have it yet. And I think obviously the nature of the offense is we're tired of hearing about these offenses. It's the worst offense we can have. However, I mean, everybody has the right of being presumed innocent, you know, and we've got somebody sitting here for 30 days without a case even in your office, much less indicted yet. All right, sir, you are Elazar Stansberry? And Mr. Stansberry has been charged with the offense of murder. The case has been filed and not indicted yet. Mr. Burbank was appointed to represent Mr. Stansberry. Ms. Holmes has joined in just with regard to filing an application for writ of habeas corpus seeking a bail reduction. And so we set it for this hearing. Mr. Stansberry's bond is currently set at $1.5 million. And Ms. Holmes, you may proceed.
Thank you, Your Honor. Your Honor, I guess in regards to the case, we have limited information. All we have at this point is a PC affidavit, which is kind of generalized. I have met with Mr. Stansberry in regards to the allegation, and we do believe once we provide a packet, possibly once this case reaches the district attorney's office for the grand jury to review, then there may or may not be an indictment. We don't know at this point. Mr. Stansberry has been in custody since November 7th. I did meet with the intake division on yesterday. They do not have the case received at the district attorney's office at this point. It is still with the police department. And so we do not have a timeline on when this case may possibly come to the district attorney's office. Your Honor, Mr. Stansberry, with the current bond amount, we do believe that it is excessive in looking at the other individuals who are currently incarcerated. Mr. Stansberry has the highest bond at the jail, him and one other inmate. And looking at other individuals at the jail, especially those who have murder charges that are not indicted at this point, their bonds currently range from $250,000 to $350,000, and I do have those names if the court needs those. Your Honor, we are asking that in light of this, that Mr. Stansberry bond be reduced to a reasonable amount. He does have family here who will make sure that they secure his presence. Just briefly, although we don't have all the information, I can say from what I do know that in regards to this particular case, Mr. Stansberry did not flee. He's actually the one who called 911 after this had occurred. He was cooperative with law enforcement and providing his statement of events and everything that happened. So I do believe that that is a mitigating factor for the court to put into consideration, that we do not believe that he will be a flight risk if the court reduces his bond to a reasonable amount to allow him to bond out. Since this has occurred, Mr. Stansberry has lived in the area since 2020, in which he was relocated from a hurricane, in which he moved with, at the time, with his children, who do reside here in Beaumont with their mother, in which they share joint custody. Since this has occurred, Mr. Stansberry has lost that apartment, where this occurred at his apartment. If he is allowed to bond out, he does plan, or is in hopes of planning, to live with his current girlfriend, who's here as well, with his parents. She lives at 25419 Richton Falls Drive in Richmond, Texas.
Judge, I had the opportunity this morning to speak briefly with Detective Jackson. Obviously, he is not here this morning. If the court would like to hear from him, I would ask your consideration, because we have one more docket. If you would like to hear from him in person, if we could maybe hold on this until next week before any substantial reduction of this bond were to be made. I went with Ms. Holmes and we both visited with intake yesterday. We're both aware of the situation that the case has not been brought in, although a warrant was walked through based on the facts they had at the time of the offense. I have brought that to the attention of the detective, not knowing if the case will actually fall in this court next door to whom it will be assigned. I have very limited amount of information, but I did make it very clear to Beaumont Police Department, and they were very receptive to the fact that this case, even if it is absent some of the documentation, such as the phone download that the detective mentioned, it needs to be brought sooner rather than later to the district attorney's office, in all fairness to the defendant. But as the court has very limited information about the facts, I think there is going to be a dispute with respect to an affirmative defense versus an intentional and knowing murder. I don't disagree with that. I think the sides are not in the same position right now, but it's kind of hard to read between the lines with a 3-sentence probable cause affidavit. I think based on what this court has done recently and based on just on the fact that every single weekend we turn on the TV and there's a murder in Jefferson County, I think that bonds in this county to protect this community, understanding of the defendant's rights, need to be substantially more than they have been in the past. And I think the court is beginning to follow, at least this court, is that trend. I'm not saying that an amount of relief is necessarily opposed by the state, but I don't believe, just based on what I know, Judge, and based on everything we're dealing with in this community, that something as low as $200,000 would be sufficient at this point.
My biggest concern at this point is the fact that this is from November 7th and you guys don't have it yet. And I think obviously the nature of the offense is we're tired of hearing about these offenses. It's the worst offense we can have. However, I mean, everybody has the right of being presumed innocent, you know, and we've got somebody sitting here for 30 days without a case even in your office, much less indicted yet. And I think that's a big problem that needs to be addressed, and it doesn't leave me a lot of, I think legally, probably required to do relief, because obviously the state couldn't be ready because you don't even have the case yet. And so that puts you guys in a bad position as well. Ms. Malfino, I think the facts are somewhat important, and I wouldn't mind hearing from Officer Jackson, however, or Detective Jackson. I just don't think that at this point, based on the time frame, that I can not give relief. Obviously, I think that the lack of criminal history is important. So that goes into this, because if we've got any type of criminal history, we'd be looking at something a whole lot different. I don't disagree with Ms. Malfino about what's going on in Jefferson County, but I also have to individualize each case. So that being said, I'm going to grant the relief. I am going to reduce the bond in this case to I'm going to reduce the bond in this case to $500,000. Condition of that bond, if made, or conditions of that bond, if made, are that Mr. Stansberry will be ordered to live in Richmond, Texas at 25419 Richton Falls Drive with Ms. Starks. Will be required to wear a GPS monitoring device and be on house arrest, other than for coming to court and for visiting with your attorney. Without my permission, you don't go anywhere else if you make that bond. If you've got doctors, if you've got different things like that, you get with Ms. Holmes, she gets with me, or Mr. Burbank, either one, they get with me, and then I either give you permission for that or not. Other than that, you're on house arrest with the GPS monitoring device. We'll know immediately if you leave the house without permission. The bond will likely be what it is now, if not more, if that happens. Are there any specific, I guess I don't really need to worry too much with a no contact, or because I'm going to have him on house arrest if he makes the bond. But obviously, you're not allowed to be anywhere near that old address or anywhere near anyone who was involved that night. You're not to have any communication with anyone involved. So that doesn't just mean contact in person. It means you can't talk to them, send message to them, anything at all. Do you understand? All right.
Judge, I'm sorry, go ahead.
I just want, will his children be allowed to, I guess, come visit him? His children do reside with their mom here. Well, they
Yeah.
joint custody, but
That's fine.
they can visit him.
Yeah, I mean, there's no allegation that there was any issue with regard to the children, or that I can tell from the little bit of information I have. So whatever that, if they have custody, I don't have any problem with that. What were you?
Judge, I just wanted to ask the court to consider, for what it's worth, the order that he not possess a firearm or be in a home with any firearm. And also,
Yes.
I don't know how to request that you order this, but I would prefer, and I think it would be beneficial to the court and to the fact that this is a Jefferson County jurisdictional issue, if he obtains that GPS before he leaves here, so that
They'll put it on before he won't be able to leave jail without it.
somebody we work with, such as Johnny's, would be able to keep the
No.
court informed of his work.
It has to be, when we order a GPS, it's part of them getting out of jail. They don't get out of jail until they come put it on their leg there, I'm pretty sure. And so, isn't that how it works on GPS? I know not on drug patches, but GPS, they can put them on.
Before they get out.
Yeah, okay. So that gets taken care of through the bondsman, and they get somebody to get that done upon leaving or checking out or whatever happens there. Okay? So you are ordered not to be in possession of any firearm. If there are firearms in the home of Ms. Starks, they all need to be removed. So if you're going to live there, then you're technically in possession of that place. You can't have any firearms there. Makes sense? Okay. We will, if there's any issue and the case is not received and indicted soon, obviously, this is something that would have to be revisited as well.
Yes, ma'am.
Okay, thank you. You can go back with the bailiff. Are you Derek Lee Williams? And Mr. Williams, in cause number 25, DCCR 1254, you're charged with the state jail felony offense of evading arrest or detention with previous conviction. That is from August 14th of 2025. The indictment alleges that you were previously convicted of evading detention in Harris County, June 4th of 2007. And so that prior evading is what makes this a state jail if you were found guilty. Your indictment further alleges the possibility, if you go to trial, is a potential for 2 to 20 in prison if you're found guilty, and that the state had offered a 4-year term if you wanted to enter a plea of guilty. And so what do you want to do?
I'll try.
You want to go to trial. So there's a rejection that you need to sign with Mr. Lewis. Y'all get that signed. I'll call you right back up here and we'll get your case set for trial. I do want to make sure you understand, though, I mean, I know we already went over this, that this offer will not be accepted after today. If you're not guilty, that's fine. That's what juries are for. But I don't want you to think by putting this off, you're going to get some better deal.
No.
Okay, all right. I'll hold it while y'all do that.
I was hoping we could agree today on a plea deal.
I'm sorry?
I was hoping we could plea deal today.
Well, the offer is what the offer is.
Understood.
It's admitted. Is there any evidence that Mr. Williams is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those other 2 prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
Thank you.
It's not an aggravated.
No, sir. Okay, so more than, all right. So are you Perry Robertson?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case? Mr. Robertson, in cause number 25 DCCR 0498, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from March 23rd of 2025. The indictment alleges you were previously convicted of evading detention February 23rd of 1998, and then again January 10th of 2000. And then it further alleges you were convicted previously of possession of a controlled substance, a state jail. All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. And cause number 25 DCCR 0498 finds you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0499, also find that you entered your plea of guilty freely and voluntarily, and those pleas of true. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you in each of those cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. They will run concurrently, which means together at the same time. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You go back with Taylor.
Love that.